Welcome, welcome. As we are entering a new year, we have a new immigration bill. I will tell you a little bit more. We will get into detail, what to expect, what is this about, and exactly what can you do. Don't forget to actually subscribe to our channel and obviously press the like button. Now, my name is Annick Koloko. I am an immigration attorney, but let's get into this. As you know, the House of Representatives actually passed a bill named after Laken Riley. Laken Riley is the young lady who actually lost her life through the hands of this immigrant from Venezuela. Now, this particular bill is quite interesting in the sense that it has a lot of support. It passed to the House and now it's actually before the Senate. And according to report, it seems like more than 46%, obviously, Democratic senators are indicating that they will be voting for that bill. Then after that, the version from the House and as well as the bill version from the Senate will come together and it will be what is called reconciliation. Now, once we go to reconciliation, then it will become a final bill and it will be sent to the president's office for signature. And after that, the bill become law. Now, in almost 40 years, it is actually noted that it will be almost the first time that we have something where both parties agree on a bill, because every previous bill, every an attempt for an immigration reform actually been unsuccessful. But there we are. Now, what exactly is going on? What's in the bill? The first thing that you have to remember is that this bill is very different from the previous bill that we have, and the last one being from 1996. Now, under this new bill, DHS actually is required to detain, meaning the Department of Homeland Security, which is the government, is required to detain any person, any individual. Obviously, we're talking about a non-US national, aka an immigrant, somebody who is not a US citizen, to be detained if they have been arrested for burglary, theft, larceny, and shoplifting. And why is that? Is because the immigrant who actually took Laken Riley Act has been previously convicted of shoplifting. Now, the idea behind it is that if he had been in detention, obviously Laken Riley would still be among us. Now, this is a huge departure from the 1996 law. Why? Because previously, you will have to have been convicted, meaning that you will have gone in front of a judge and either a jury or a judge will have rendered a decision on your case. And then you are convicted, and at this point, then you may face mandatory detention, specifically if it's what is called an aggravated felony. What was an aggravated felony before is somebody who had a sentence of 365 days and more. But now we have a big departure from this previous law, because now you don't even have to be convicted. That was actually the main argument, the due process that everybody will be afforded when they will find themselves in deportation, in removal proceedings. You will be able as an attorney to argue that your client should not be actually deported based on an arrest and even or being charged, as long as the conviction was not final, meaning this was actually a pillar of the previous law. But now we don't have that anymore. You have some critic of the law saying that yes, now this is actually an attack on due process of immigrant, because you could actually be arrested, you could be charged. It does not necessarily mean that you will be convicted. But there we are. This is exactly what's going on. Now you just have to be arrested. If you're arrested, if you've been charged, the Department of Homeland Security automatically will actually detain you. This is very important. Think about it. And this is something as actually something that is as probably not as very serious, right? Not saying that we don't take it seriously, as shoplifting. Shoplifting, think about it. Shoplifting is something that happens more often than we think. But shoplifting, burglary, obviously theft, larceny, meaning here we're talking about all crime of theft. I mean, this is basically the great change, and this is a significant change, in affecting those of you who may find themselves in this particular situation. Now, the problem is once you enter, when you are in detention, it doesn't stop there. The law even go a little bit further. And I want to talk to you about the second part. What's going on here? Not only that, but because the Republican state have been trying for years and years to actually sue the federal government for what they perceive as not, applying immigration law as it should be, right? For example, not enforcing the border. I mean, that has been a point of contention between the Democrat and the Republican. But now that we are particularly here, it has been now put in the law. And what do I mean? This law gives the right to the state to sue the federal government if they believe that an individual, here we're talking, of course, about an immigrant, has been unlawfully present in the United States and did not possess the necessary document when they were applying for admission. What does that mean? It means that imagine you present yourself at the border, and then obviously here they're talking, sideways, obliquely about people who are presenting at the border, seeking admission, either based, being paroled, either based on humanitarian reason. We're talking about, like instance, for example, like seeking asylum. But if you enter the U.S., and according to the state, you did not have the sufficient documentation, it means that you should not have been admitted, then the state can actually turn around and take the federal government to court. And this is actually in line with the argument that the Texas and bunch of conservative states here, Republicans, that have been arguing for years and years and years, stating that basically that because of the federal government failure to actually apply immigration law the way it should be, they are the one actually having to burden, themselves, obviously with the decision of the federal government. But now they have the possibility to sue them. Don't forget that Texas actually sued the federal government, and the case has been meandering through court, and that was the idea. But now that the Republicans have the majority in Congress, guess what? That's exactly what we see in this particular law, the Laken Act. Now, not only that, but they say also the state has the right to sue the federal government if the individual has been charged with or arrested or admit having committed each act that constitutes the essential element of burglary, theft, larceny, and shoplifting. Again, meaning that basically not only, remember previously we talked about the fact that now if you've been arrested, right, if you've been charged and convicted, then you will face detention. But they also adding that if the federal government does not do that, if they fail to do it, then the state have the right to sue the federal government. You can imagine that that's going to put a lot of pressure, obviously on the federal government to move forward and actually to apply the law, because this is a law that is being voted by Congress. Finally, they also go further because the bill also authorizes the state to seek what is called injunction relief, right, over certain immigration-related decision or alleged failure by the federal government if the decision or failure can harm their resident. And then here they're talking about financial harm more than $100. Again, this is another argument that Texas and the Republican state have been putting forward time and time again, saying that the fact that the federal government is failing to apply immigration law as it should be is actually be a financial burden on the state. And the most example that they always refer to will be, issuing travel license, of course, a school here of providing education to children of immigrants. This is the argument that has been coming over and over again. Now, they have, under this new law, they have the right to turn around and sue the federal government for actually burden them for its failure to apply immigration law. This is so vague, right? That's my analysis of it, because exactly how are we going to define all of that, but we will keep you posted about that. And then obviously they even go specifically, they give more example when the state have the right to sue the federal government. This is a huge departure, because you have to understand that immigration is the purview of the federal government, not the state. This law is basically stating what the Republican state have been saying, that they do have a right. This is a huge departure, because under the Constitution, the federal government is actually applying, enacting the law, here when we're talking about immigration law. But there we are. Now, specifically, the state has the right to do what? To sue the federal government if the federal government decide to release somebody from detention. This is, again, another pressure to keep people in detention, because once you enter in detention, guess what? At this point, you have to apply for you to be released. The government has to make a decision if they believe that you're not a flight risk. But now they're going to have to think, are they going to get sued? Are they going to get balled up trying to defend themselves all over, having every state that feel like you're just filing suit against the federal government? That's probably what's coming. Now, you also, and again, if you're seeking asylum or if you're seeking admission to the United States, right, and you don't fulfill the requirement, we talked about that before, they have the right to sue. Again, it's going to be quite interesting to see how are they going to make that determination. And also, if they fulfill, if the federal government fail to fulfill a requirement to stop issuing visa, that one is very important, to national of a country that unreasonably deny and delay acceptance of national of that country. This is what they're doing, because you have to remember that under the President Trump's first term, they were trying actually to put pressure on country to take back their citizens. Obviously, if you're going through deportation, removal proceedings, and at the end you have an order, then you have to leave. Then obviously some country will not take back their citizen, right? They try obviously to apply pressure, by stating that they will be withholding aid from the United States. Now, this is something then obviously you have to think about, right? But think about it. Now, what they're saying is that, you know what? If the country is not cooperating with us, the United States, or if they refuse to take their citizens that we want to deport from our land, but automatically the federal government has to stop issuing visa immediately. What does that mean? If they have to stop issuing visa, it means it's going to put pressure, meaning the action of a few, the action of the government to actually decide not to cooperate, or maybe probably drag their feet in order to take their citizen back. But guess what? Now we're going to punish you. We're going to punish you by doing that. Everyone that wants to come to the United States who is a citizen of your country, but that's not good. That's a no-go. And that may be diplomat, I suppose. I'm not sure, because it's not very clear. Student, business people, obviously tourists, you can see very, very clever. That's in the law. And then obviously, finally, the state have the right also again to sue the federal government, if they are in violation of limitation on immigration parole. Meaning, again, they're trying to do, the idea is the Republican believing that the border are open and that obviously the federal government failed to do their duty because they're just admitting people. And the category of people that have been admitted, according to the Republican, are people who are paroled in. Now, they can sue the federal government because they want the federal government to use that very sparingly on a case-to-case basis. You see, this is a huge departure, meaning this is enormous. It's enormous, right? And then finally, obviously, if you come to the United States and you've been ordered removed before, they want the federal government to detain you automatically. Normally, if you have already an order of removal, you've been removed before, you're trying to re-enter before, obviously, the period of ban that has elapsed, then normally it's an automatic deportation. But this is not very clear. We're not really sure whether if you've been removed before and then you come, maybe let's say you were banned for 5 years and then you come the 6th year, is that still applicable? See, it's not very clear, but as you can see, the spirit of the law here is actually to put pressure on the government for what the Republicans perceive as the federal government failure to apply immigration law. My name is Annick Koloko. Don't forget to follow this page. I hope this was useful to you. Don't forget, to ask questions for us. We're here for you. Thank you very much. Goodbye.